Okay, welcome back. Give me a couple of seconds. Welcome. So I just noticed that for the last scenario, a couple of other responses were left on the chat. For example, Alex says that was really naughty of the second paragraph. I think Gabby said no consent given from members, guessing that's for the second purpose. And Laura says unauthorized sharing of data, absolutely correct. Catherine said first paragraph is okay, but cannot pass on to details or onto a third party without permission, absolutely right. And then Molly said the members' details shouldn't be shared with friends or anyone without consent. That's consent coming in again, that's correct. So yep, quite a good few good responses there, so thank you. Okay, so what we're going to go through first for this session is actually now look at some of the lawful basis for processing. We saw the principles, and one of the first principles there was the lawfulness. And you remember I said for you to actually process personal data, you must have, and I will say and document, not just have, you must have and document a lawful basis for processing personal data. Here are the lawful bases as specified within the GDPR. The first one here I put down is consent, and consent seems to be the most common one, and mostly because of the fact that we do marketing and we do direct connections or direct interactions with service users, data subjects, and perhaps our services lend itself to consent. So consent is the first one, and you probably already know what this means. It just means you must get the permission, or you must get the consent of the person whose personal data you want to use before you go ahead and use that personal data. We'll look at consent in some detail after this section, but consent is the first one. So if, for example, you're collecting information, that particular scenario we just looked at, you wanted to collect the name and email address for the purpose of sending them a newsletter. Do you agree? Do you consent? Yes, please send me newsletters. Straightforward, each in a kind of way. Second lawful basis is contract. So contract here really is a good one from our perspectives as employees of an organization, for example. So this is when you have a direct contract with the person whose personal data you're going to be processing. Employment contract, for example, is a good example here, where you say yes for you to provide employment services and for you to work for an organization. We would need to have information about you, about your bank, about where you live, your next of kin, for the purpose of employment. So you enter into a contract with the person collecting or the organization collecting your information. That is a lawful basis. Legal obligation. Hello? Somebody's phone's off the hook. Thank you. Legal obligation. If you use legal obligation as a lawful basis, it simply means you're trying to fulfill the legal requirement, perhaps of your organization itself or of a third party. And a case in example here is you have the HMRC. They require for an organization to send them information about tax or for tax purposes. So financial details, salary information. So you as an organization have a legal obligation to collect relevant personal data from the employee for that particular purpose. So in that respect, you have a legal obligation to collect and process personal data. Vital interest. Vital interest is usually when you have to act in the best interest of the particular individual. So it is usually a matter of life and death for the individual. If you don't process the personal data, they may die. An example is you come across a data subject who perhaps has a health emergency and they may be wearing on their person some information about their health, about their personal issues. In that situation, you can't get consent because it's an emergency. There's a situation of life and death. You are obligated, or you are entitled, or you are allowed to process their personal data, check the information within their person to understand what issues they have, what conditions they have, who their next of kin or their SOS contact is. And in that situation, your lawful basis for accessing that information and processing it is vital interest. Lawful basis number 5 here is public task. If you're processing information on individuals in the interest of public task, your duties to carry out a public task, then you're perhaps going to be in one of the organizations such as health services, the NHS. They carry that, they carry out processing, and they carry out their tasks or their duties in respect of the fact that their organization have a public duty to perform health service, to give direct care to patients. So if you're giving any of those care and any of those sort of services, then your lawful basis for doing those work or for doing this processing, for asking about information, name, dates, date of birth, details, NHS number, would be public task. That would be your lawful basis, very likely. And the final one here is legitimate interest. Not a very popular one, used to be very popular in the private sector and a lot of organizations. In fact, public sectors can't use legitimate interest. But legitimate interest just means you as an organization feel that it is in your best interest as an organization, for your benefits mostly, to have access to the individual's personal data, to have access to personal data of individuals, and you are using legitimate interest. But there is a catch-22 here. You have to be careful, because in order for you to use legitimate interest, you have to do a legitimate interest assessment test to check to see if the legitimate interest of the data subject does not override your legitimate interest or your interest. If the data subject's interest overrides yours in terms of their rights and freedoms, if that's the case, you cannot and should not be using legitimate interest as a lawful basis. So in those circumstances, if legitimate interest test is done and you find out, okay, actually the data subjects are in a position where their interest overrides why we want to use their data for our benefits, then legitimate interest might not be the right lawful basis. You need to look at one of the other 5. Special categories of personal data. We saw this earlier on as a type of personal data. Now, the law requires, or the GDPR requires, that not only must you have one of those 6 lawful bases for processing. If you're, however, processing special category data, you must have what's called an Article 9 condition in addition to one of the 6. And here are the 8 conditions specified in Article 9. So basically, if you're processing special category data, I'll use health service again as an example. You first identify one of the 6. So most likely public task, 6.1e. So if you're using public task, but then because we have a lot of health information, a lot of social care information, a lot of sensitive, highly sensitive data, the law says we have to then pick one of the 8 conditions in addition to the lawful basis. So if you're looking at data protection agreements for healthcare organizations, for people who provide such services, you'll always see the lawful basis for processing will be an Article 6, one of those 6, and plus an Article 9 condition, one of these 8. And I think it was mentioned earlier on about explicit consent. That's because this is special category data. There should be no doubt that consent was given. There should be no ambiguity that consent was given. It has to be explicit, clear as mud. It is there. It is, statement is there. The consent was given. There is no confusion about who, when, how. It is all clear. That's one of the conditions. Number 2, employment law obligations. If you're obligated by law, employment law, like we saw contract earlier on, and you have to process perhaps for occupational health purposes. You decide you have to carry out a health check or a health assessment or occupational health assessment on your employees. Then your special category condition will be an employment law obligations because you're required under the Health and Safety Act or some other act, but it has to have a place in law if you're using that condition. Legal claims. Legal claims are usually where there are claims brought about by insurance companies, either through negligence or other claims involving the access to sensitive or special category data. Number 4, health and social care provision. This is one of the special category conditions that we use in healthcare services. So you have an Article 6 for public task, and because you provide health and social care as part of your usual activities, you are allowed to use this particular lawful basis special condition 4. In public health, so organizations, especially in the past couple of years, who have been carrying out processing activities with relation to giving information, research, or whatever it is around COVID, it's in the interest of public health, and they're trying to look at why we need to process all this highly sensitive information. That could be one of the, that could be the right condition for processing. The vital interest. Similar to the Article 6 one we looked at just now, this is the vital interest of the individual. So the first one was, okay, we could perhaps just have been looking for their name, address, or something else in terms of an emergency, but in special category requirement, Article 9, you need to make sure that it's in the vital interest of the individual for you to have access to those highly sensitive health information that you need to get from them to save their lives. And then any data made public by data subject themselves. So if data subject or individual, yourself or whoever, has decided to make certain information public, one of those special category lists we saw earlier on, race, ethnicity, religion, political affiliation, health data, biometrics data, if you decide to make it public and if there's a need for you to process that, you're able to use that as a condition of processing. And the final one there is archiving and research in the public interest, which again goes to what has been happening in the last couple of years in terms of carrying out scientific research in the public interest for the fight against the pandemic and COVID. So these are special categories, conditions that you have to have if you're going to be processing one of those special category data types. So let's look at consent in a little bit more detail. Here's a definition from the GDPR. Any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement or by clear affirmative action, signifies agreement to the processing of personal data relating to him or her. These actually do get tested when we look at the types of consent that we say we are getting or using from data subjects. The questions are asked, is it freely given? Was that consent freely given? Or did you make the consent a condition of something else? Say, give me your consent and I will allow you access to our crown jewels. No, that is wrong. That is not freely given. It has to be freely given, not tied to any conditions. Specific, that's important because we were saying about purpose limitation. It has to be specific. I want your consent to be able to send you newsletters. Specific. I want your consent to be able to send you SMS messages. Specific. If you then go and send an email, and I've had one of these as a complaint, email, that's not what the consent was for. I gave you my phone number so you can send me SMS messages. That's what I ticked on the box. I'm now receiving email messages from you. Why? That's a question I had as well from one of my clients. And it has to be specific. Informed and unambiguous indication of the data subject's wishes. This is about informing the data subject before you collect the information. Why do you need my information? Why do you need to have this? You know, what are you going to be using it for? There's no room for any unambiguous statements or conversations, it has to be clear. You inform the patient, the data subject, why. Okay. Clear affirmative action. This is important because what I see or tend to see in some places is there are forms, and we might see it later, there are forms that are being used to collect consent, and the form might just be a statement, but then the data subject has not been allowed to make a signature, to make a mark, to actually show that they took affirmative action. They not only read it, but they agreed somehow to say, here is my consent. Was it by a signature? Was it by a statement? Was it by a yes or no? Was it by a cross? And you have to try and look for that if it lends itself to having affirmative action. And this signifies agreement for the processing of their personal data. So consent is not that straightforward. It is straightforward in a sense because that's the most common way of getting something. Oh, have you got consent? Yes, we have. Now you then have to think, what type of consent? Was it valid consent? If it's not valid consent, you would be in breach of the requirements of the regulations, and you need to then adjust your process or the way you get consent. So valid consent. It requires a positive opt-in. There has to be some affirmative action. So please don't use pre-tick boxes or any other methods of default consent. And you tend to see this even under the PECA rules with websites, where you go on a website, a pop-up banner comes up and says, by continuing to use this website, you agree to the use of our cookies collecting your information. No, that is invalid. By continuing to do something does not give positive opt-in. You have to give the data subject a choice to opt in or to just say object or not to do anything, not to accept. You know, I'm not taking a consent. I don't want that. So do not use pre-ticked boxes. Explicit consent requires a very clear and specific statement of consent. And this is going back to the previous slide. Explicit consent. It has to be clear, specific statement of consent. So it could be that it's written and signed, it's written and acknowledged, it's written and verified, but it is clear, there's no ambiguity at all. And this is also important that we have to make it easy for the data subject. I get really, I don't want to say the P word, but really annoyed when I go on a site or go to sign up for a service, and it was so easy to get consent and click the tick box. And then when I want to withdraw consent, I cannot find anywhere on the website, anywhere on the pages where I could easily do that until you receive all the information, and it might say at the bottom, in order to stop receiving this, click here. But I give that consent very easily by ticking a box. I want to be able to withdraw that consent very easily by ticking a box. So you have to not only get the consent, make it easy to withdraw and tell them how to withdraw the consent. And the final point here on consent, for consent to be valid, you need to keep evidence of consent. A lot of people fall down on this, and that's because perhaps consent was got 2 years ago or perhaps 1 year before 2018 pre-GDPR and has not been refreshed since, and it might have been collected on paper forms, and those paper forms might have been filed off somewhere in the archive. So when you then check, and as a data protection officer, or perhaps if you've got data protection coordinators within your area, and they're doing a review or an audit of your compliance, and they say, okay, let's check consent. You don't have the records. There are no clear records. You're carrying on this processing. However, where's the consent to back it up? Because you would have needed consent if especially you said that's your lawful basis. You want to know who consented, when the consent was got, how did they consent, and what you told them at the time, what information, so the information they were given at the time you received consent, what were they told? Were they told what were you actually doing now? Is that what they were told at the beginning? If it has changed, then you need to carry out a review and fix things, put things in place. So it's important to keep evidence of consent. If you're developing new systems or new processes that would involve consent, always ask, Will this process or system be able to show evidence of who consented, when they consented, how they consented, and what you told them? The how is important, and that's because sometimes you can get consent over the phone. Do you agree for us to do X, Y, Z? And they might say yes over the phone. The answer could be yes, we agreed for X, Y, Z. But you should have a process to capture that, document it, put it in record. So it's when there's a review or there's some fallback or somebody says, no, I did not consent, you can refer back to records to demonstrate that you did get consent. Children and consent. Within the GDPR, there are specific provisions on children's consent for information society services. So for organizations, if you deal with children's society services, are defined as services that are online on the internet, like mostly all the social media platforms that the children do go onto these days. There's a specific requirements that they must have consent before they can provide those type of services to children. That's defined in Article 8. And basically it's saying where children really are under the age of consent, in the EU GDPR, it's 16, but we're allowed to reduce that, and UK has reduced that to 13 under the Data Protection Act of 2018. So parental consent is required for children that are under 13 years old. Parental consent is written there, but it also could mean guardians or people who have power of attorney to act on behalf of children. Any questions on consent at this point? Let's see the...
John, could I just maybe ask one? It's Alex. So just to think, I just remember when when GDPR, sorry, came in to the front originally in 2018, there was a lot of conversation around consent versus legitimate interest at that point. So, and I think there was what tended to happen, there was a flurry of organizations purging their mailing lists, or running out to refresh consent, and real sort of scrambling to make sure that they had all that on file. It seems to me over time that not so much from within the charity sector, but certainly marketing and things like that, it's kind of moved away a little bit from consent, and the legitimate interest would seem to be the methodology that is being used to collect that information. Are you saying then that that's wrong and we should still be collecting consent, or could you explain a little bit more about the balance between consent and legitimate interest?
Sure. Yeah. Consent and legitimate interest are at the top and bottom for that particular reason. Exactly for that particular reason. Legitimate interest should be the last resort. It should never be the first resort. And that's because it's very difficult to balance the interest of the organization against the interest of the data subject. The data subject's interests mostly always override that of the organization. Yes, you can use legitimate interest, but you have to have a clear justification. You have to do what's called the legitimate interest assessment test. So you define the necessity. Is it necessary for me to collect this personal data from the individuals for this purpose? Is there any other way I could do this without collecting this personal data? And most importantly, is my interest as an organization greater than the rights and freedoms of the individual? So legitimate interest was used when the Data Protection Act first came out as the easy way out. It was used as the easy way out because then you didn't have to go and collect consent. You didn't have to go and do all the sort of documentation that you might want to do when you're looking at the other types of lawful basis, especially consent. So a lot of organizations were using legitimate interest and tried to stick with it. Legitimate interest, especially within advertising agencies, organizations, is difficult to justify for that same reason, where you can get the balance between the interest of the organization, because I want to grow my profit by X amount and I need to have personal data or your personal data so as I can sell it to make marketing or to make profits. That interest or that purpose would never be greater than my interest to protect my personal data and to protect my rights and freedoms as an individual will always override that. So what I'm saying is you need to look at the processing activity that you're trying to achieve. And you need to look at if it's by consent or if it's by contract. You start at the consent at the top and you work your way down that list. And at the very end, you might, legitimate interest would probably be a last resort for most people. But usually it starts with consent. Do I need consent? And as a data subject, what's happening these days is a lot of data subjects, you and I, are becoming more aware of our data subject rights. We're becoming more aware of our rights under the GDPR, and we're asking questions. And we're asking questions that, did I give consent? Did you ask for my consent before you sent me stuff? And we begin to see more of that. So it's important to look at the processing activity or its purpose, what you want to do, and then check with the lawful basis saying is consent the right one, and consent has to be right because in order for me to do this, I need to get the permission. You can't just go and start using it. If you can just go and start using somebody's information without telling them and think that, they'll expect that to happen, then you're saying you're going to use legitimate interest because I don't need to tell them. I'm just going to go ahead and use legitimate interest because it's for the benefit of my organization. But if you look at that statement there and say, okay, you know what, I think we need to have the permission because we are going to need for them to consent.
Thanks, John. There's a couple of hands up in the room as well. I've got Donna hand up. Do you want to shout out your question?
Hi. We did some first aid training last week, and we were told that any accidents that happen on the site, sorry, I'm from Fitzrovia Community Centre. We were told that any accidents that happen on site, you need to keep a record of that accident for 21 years or 25 years if it's a child who's got special educational needs. And that to me doesn't really fit well with what you're teaching us about, about how long you keep data, safe storage. How do you keep something safe for 21 years, especially if it's been written on a paper form?
Okay, I think the first question is, do you need to keep the data for 21 years? If the answer is yes, then that's been defined and decided by someone who's either familiar with the reason for the record retention. Within the healthcare, there's a National Health Service record retention schedules, and it defines how long records should be kept for each type of services you'll find within healthcare and social care. So it defines the terms and the requirement of record retention. So within your environment or within that setting, it might have been defined by the health and safety executive. There will be a record retention schedule and will state that, for accidents on premises, we expect these records to be kept for 21 years. How you keep it is a different story. If you're going to keep it paper records, then it has to go into archive for 21 years. If you're going to keep it digitally, then it has to go into a digital store, maybe in the cloud somewhere, for 21 years. But the actual retention period is defined by the organization, by the processing, by any other laws around retention, just like you have record retention within HMRC or for tax purposes, financial records and stuff like that. It all has to be kept according to the requirements for the person deciding the purpose. Okay, so but it's important that yes, you can keep the records secure and safe from tampering, for that 21-year period. So if it's going to be paper records, it's got to go into an archive somewhere. You have a process that says after you've used it, it goes into the archive and stays there until it's recalled. Okay.
And Ruth, did you have your hand up or has that gone down? No? Okay, back to you, John.
Okay, so let's look at data subject rights. Now, what makes GDPR really, really exciting to me is because I get to learn about my rights as an individual, my rights as a natural person. I'm still living, and while I'm still living and breathing, I'd like to know what my rights are because I'm surrounded with a wealth of information, a wealth of systems, an ecosystem of information technology. Everybody wants a piece of my data. And we're going to be seeing that it's not going to get less, it's going to be more and more. But the other thing is there's so much advancement in information technology with AI and all the technologies you see that is it could be scary at times and maybe sometimes intrusive. And you know, as a data subject, I want to know what my rights are. And strangely enough, we're beginning to see more and more data subjects exercising and flexing their muscles because they're beginning to know their rights. And hopefully, you know, everyone on the course, on the training today would look at this from the perspective of you as an individual, and this is your data, as well as look at it from you working with your organization's personal data that you perhaps protect for your service users. So, but if you look at it from your point of view, what are your rights as data subjects? The first one is you have a right to be informed. And I think we've mentioned this a couple of times already today. But if you want to collect my information, I have a right as a data subject for you to tell me what you want to collect, why you want to collect it, what you're going to use it for, where you're going to store it, who you're going to share it with, where it's going to be kept if it's going outside of the UK, how long you're going to keep it for, and those kind of information. It is a right of an individual under the GDPR to be informed. So organizations then, in order to comply, have to ask themselves, have I given the individual information about the data I'm collecting from them? Go ask yourself. And I think I mentioned earlier on, privacy notice, privacy policies, those are usually the instruments to get information or more information out at the point of collection. You tend to see them on websites and you tend to get referenced to the website. But be careful, because on websites, you might have generic privacy notices. It may be so generic, you don't even know what it is they're collecting and what it is they're doing with the data. And it's saying, we may do this, we may do that. I want to know what you're doing with my data. So I might want something more specific. But you do have a right to be informed. Your service users have a right to be informed. And if they think they weren't informed, they have a right to call you to ask the questions. I have a right of access. So do you. Data subjects have a right of access to their information that you hold within your environment, that you process, that you keep, that you store, that you use. It might just be sitting in a server somewhere and you're probably not using it. I think that's one of the other things people say, but we're not doing anything with it. It's just there. Just there is called processing because you're storing it. It's kept in archive. It's processing because it's stored. It's in. You still have responsibility for it. So I have a right to access any information you hold and that relates to me. And we're beginning to see quite a lot of data subject access requests coming in through to organizations, even in the non-profit charity sector. There begin to be an increase in subject access requests. And not only should you have not only should you be given access to your information, there are other mandatory requirements that the organization must tell you. We will look at those when we talk about subject access rights in the next part, I think, of the course. You have a right of rectification. You have a right to say, my information with you is not correct. That address that you put on that letter or whatever it is wrong. Therefore, please correct, please rectify. And the organization has an obligation to make corrections within 1 month. Most of data subject rights have a window of 1 month for the organization to resolve and respond to the request. So that correction, that rectification is a right. I also have, and you also have, a right of erasure. So do your data service users who you hold their data. Right, this right of erasure is not an absolute right, it's in certain circumstances, but this is sometimes also known as right to be forgotten. And I have just helped an organization go through this for a particular request to be forgotten. And I'll give you a quick scenario. The request came in and said, and it started with, I have been receiving these emails from you about a survey, and I don't remember consenting to this. You've got my name on all your systems and your mailing list. Can you please remove, in fact, please delete my records from any and all of your systems. I am exercising my right to be forgotten. That was the essence of the request. So that came into this organization, and they were only used to doing subject access requests. So this erasure right to be forgotten was a first occurrence. And so the initial thing the organization thought was, okay, we will remove the email from the mailing list, and that should satisfy the user. But then when you start to look at it, it's all and every system that we have. If that person's name, email address, any other personal data within any of our systems or any of the organization system, it needs to be erased, deleted from that, except where you have a legal reason to keep any of the information, maybe for tax purposes, invoicing, whatever it was, you can keep that and you can retain that. But you have to go beyond just the mailing list, because you may have sent information to other users, whatever the cost was or the purpose was, that the person's name is on that mailing on that address. So that must have gone to somebody else. Within your organization, it could have been shared with the other departments, it could have been shared with your team, somebody else could have sent the mail when you weren't there. So you have to now look at your processes and think about it. Plus, the other thing is you have maybe meeting minutes or stuff that you say, oh, here's a list of our users on a particular service or whatever it is. And guess what? You store that on your server. It goes to your shared drive. That person's name is in server's shared drive storage. It must be deleted. So the right of erasure, it's a painful one if you have a complex systems or you have a huge walls of information where it might reside. You have to be seen to have done quite an exhaustive search to get rid of it. And then you respond to the data subject, of course, confirming what you have done. If you're going to retain any of the data, explain why and the legal reason for doing so. Data subjects have a right to restrict processing. If, for example, they're not happy with the way their personal data is being used, they can request that you stop processing, keep the data still on the system while your concerns are investigated. So you restrict that processing. You might stop whatever activity it is for that particular individual. You still have the records, you still have their data. They haven't asked for it to be erased or deleted. They've just said they're not happy with what's going on here. Can we restrict the processing? Can you stop until we get to the bottom of it? And then once that's over, you can then resume processing or adjust, refine, change whatever you were doing with the information. We also have a right to data portability. This basically is to make things easier for data subjects and individuals when they change service providers. So moving from one service provider to another, you have a right to take the information given to service provider A and port it across to service provider B. This usually happens in utility providers, for example. There's a good example where you can say to one service provider or this other. You probably don't tend to get involved. The service providers will talk to each other, and based on your authorization, they can port your data from service provider A to service provider B. The same thing with banks. So that's your right to data portability. But be mindful that you can only port the data that you have provided yourself to the organization. We also have a right to object. Now, this is interesting because you can at any point in time say, I object to you processing my data for this purpose. And the organization would then have to look at it and say, okay, if you object to processing your personal data, again, it's not an absolute right because it's only in certain circumstances. If the information is required to satisfy other purposes like legal requirement, you cannot object to that. If it is to provide, for example, direct care, which is governed by the health and social care, right? And we need it to provide this service for you. You cannot object to that. You have to understand that you cannot object, and the processing has to happen. Number 8 is very pertinent to what's going on in the information age. The right in relation to automated decision making and profiling. This is happening a lot because systems are beginning to pop up all over the place. Automation. You hear about automation, AI, and profiling. And if, for example, a particular organization is processing your information for the purpose of giving you a service or an outcome based on automated processes, you have a right to say you're not happy with the outcome if you're not happy with the outcome, because it was all based on automation, and you have a right to request that there's an intervention of a human person to look at the outcome, to review the outcome, and consider the outcome that perhaps wasn't favorable. So if there is automated decision making or profiling in services or systems or what you're buying into, as part of right number one, you must be informed upfront that your personal data will be used for this particular purpose through automated systems that would give an outcome of X, or that would go through either without intervention of humans or will be reviewed at the end. And you also then have to be told that you have a right to request that someone else looks at the output. So these are some of our rights, and they're very powerful rights if you think about it, because this is great for us as data subjects. Not so great for organizations as these rights start to get exercised, especially if the organization has not put in place the right processes, the right systems and compliance to deal with these when they pop up. So if you don't have a process that can manage the rectification, the access control, access requests, you might find that you get overwhelmed with requests and your resource will be strained, or perhaps you don't have the knowledge and expertise in house to deal with some of these. So you have to make sure you are able to respond to these, because 1 month is the time limit for most of these anyway to respond to the data subject. Any questions on data subject rights? In the absence of questions at this point, I'd like to say thank you for getting through the first part of the journey, and I hope you have found it useful. There are 1 or 2 things that you might be able to take away. If not, we're going to continue with part 2, I think next week. And after wrapping up part 2, we'll go through a whole summary of the journey from part 1 and part 2. And we'll have some other questions, I'm sure, and some useful answers. And I'm going to be giving you a few resources as well at the end of part 2. So hope to see you then.
Thank you, John. That was really interesting. You've managed to make a complicated subject accessible and interesting. So thank you for that. And I think, yeah, if people can come to the next part, that's going to be really great. I, for one, am particularly interested in that bit, part 2, because I think that's, you know, well, so we've got all of this information now. What do we do with it as an organization, and how are we, you know, how do we sort of stay compliant? And I think probably that has drifted for lots of organizations since the initial data protection legislation was introduced. So yes, thank you so much for your time. I'll be sending out evaluations for the first part, so if everybody could just complete that so we can work out where we need to improve or what we've done well, that would be lovely. And yeah, notes and video will all be uploaded to the website when we're done. I think because of the break, I might have chopped the video into 2 parts, so I'm going to have fun trying to put that back together again. Or we'll have 2 parts of training and 4 parts of videos. But anyhow, thank you so much, everybody, for coming. Have a lovely evening, and thank you, John.
Thank you all.
Thank you. Bye-bye. Bye.
Can we contact John if we need to?
Yes, you can get through to me through Alex, through the VAC team.
Thank you.